法案。本會現在恢復合約第三者權利條例草案二讀辯論。審議條例草案嘅委員會主席梁繼昌議員就委員會嘅報告向本會發言。梁議員。
Mr. President, in my capacity as Chairman of the Bills Committee on Contracts, Rights of Third Parties Bill, I report on the deliberations of the Bills Committee. The Bills Committee supports the Contracts, Rights of Third Parties Bill, hereinafter the bill, which seeks to provide for the enforcement of contractual terms by third parties and related matters. The Bills Committee notes that, in response to the concern raised by the Hong Kong Bar Association, deeds of mutual covenants, DMCs, are to be excluded from the application of the bill because the law relevant to building management and enforcement of rights under a DMC consists of a range of applicable legal provisions under the Building Management Ordinance, Chapter 344, the Conveyancing and Property Ordinance, Chapter 219, and the Common Law. These applicable legal principles create a unique and intricate legal regime which sets clear limits on the enforceability of land covenants. The current legal regime for the enforcement of a DMC has over the years developed specifically in response to the needs of regulating the occupation and management of multi-story buildings and estate developments in Hong Kong. Any change to the DMC regime will affect a large number of people, and it would be inappropriate for the bill to alter or relax the legal regime of DMC without full consultation specifically aimed at reform of this branch of the law. To address the issue that a DMC may contain terms not relating to land, the administration has proposed to amend Clause 3, subsection 2 of the bill so as to clarify that all provisions in a DMC, as well as a covenant relating to land, are to be excluded from the application of the bill. The Bills Committee has sought clarification on whether excluding DMCs from the application of the bill would render tenants of private buildings and users of common parts of private buildings who are not owners of the private buildings unable to rely on the bill to enforce a term of the DMC. According to the Department of Justice, as tenants of private buildings and users of common parts of private buildings are not owners of private building, they are generally not entitled to bring an action under a DMC. The exclusion of a DMC from the application of the bill does not act or diminish the rights under the DMC. Neither does the exclusion preclude contracting parties, if they so intend, from conferring an enforceable right of action against a tenant or a user of the common parts of a private building, so long as the requirements under other applicable laws are complied with. The Bills Committee, Mr. President, notes that a third party can presently seek to enforce a contract from the court through devices such as agency and trust. Members of the Bills Committee have asked whether the rights of the third party to enforce a contract would be diminished following the implementation of the bill. As clarified by the Department of Justice, the bill, if implemented, would provide a third party with an additional channel which is more convenient to enforce the contract if it is the contracting party's intention to permit a third party to enforce the contract. Mr. President, the objective of the present reform is to confer rights on a third party rather than to derogate from them. Thus, the existing rights of a third party under statutory law and at common law would not be affected after the implementation of the bill. On the implementation arrangements, the administration has been asked to step up publicity efforts in the promotion of the new legislative regime with a view to assisting the general public and various stakeholders in preparing for the implementation of the bill. In response to members' suggestions, the administration has advised that it would liaise closely with the legal professional bodies in this regard. The administration also agreed to consider the feasibility of bringing the new legislative regime into operation 1 year after the passage of the bill. Next, Mr. President, I would like to give my personal views on this bill. Mr. President, the doctrine of privity of contract provides that a person who is not a party to a contract cannot acquire any rights under that contract or be subject to any of its burden. This remains the general rules in Hong Kong law. The fact that a third-party beneficiary of a contract could not enforce the contractual benefits in its favor was generally regarded as unsatisfactory, and indeed a number of devices were developed in the past in order to circumvent this aspect of privity doctrine. In addition, a number of exceptions were developed where third-party rights were recognized. These devices and exceptions can be artificial and complex, so that there were cause for reform of the third-party beneficiary rule. These devices and exceptions remain, despite the enactment of the bill. The bill follows the major contents and direction of the English Contracts (Rights of Third Party) Act 1999. Very generally speaking, the bill allows a third party to a contract the right of enforcement, provided that either limb of a two limbs test is satisfied. First, either that a third party may enforce the contract if the contract contains an express term to that effect, or if the contract contains a term which purports to confer a benefit on a third party, that party may enforce that term unless on a proper construction of the contract, the parties to the contract do not intend the third party may do so. Mr. President, I support the passage of the bill. Indeed, I think the bill should come at an earlier date so that Hong Kong's contract law system can be more in line with that of most other common law jurisdictions. There are three types of contracts which I would like to mention here. These are contracts which would have more bearings on the daily lives of the citizens of Hong Kong. First, contracts regulating the relationship between employer and employee. Mr. President, the bill will not alter the contractual agreements entered into between employers and employees in the capacity of parties to an employment contract. However, the bill contains a provision under Clause 3, subsection 4, to prohibit a third party from enforcing a term of employment against an employee by a third party. This provision does not apply to an employer. In simple terms, a third party may still be able to enforce a term of an employment contract against an employer, provided the conditions of the enforceability requirement in the bill are satisfied. This provision gives more protection to an employee who is often seen as the party with the weaker bargaining power in an employment relationship. Second, I'm also concerned about consumer rights in a consumer contract. The Honourable Dennis Kwok raised the question in the 7th May 2014 Bills Committee meeting. Essentially, the requirement of the enforceability test under Clause 4 of the bill, which I have highlighted above, will not enable consumers to have direct and convenient remedies for damages, injury, or loss suffered due to a breach of a contract to which he was not a party to. Now, this view was indeed shared by the Consumer Council. The government, in response to this concern, merely stated that the government shared the view of the Law Reform Commission and considered that it is more appropriate to give effect to the contracting party's intention, whether to confer legally enforceable right on a third party. This response, I believe, is not satisfactory, and I would urge the government to review this aspect of the bill at an appropriate time. Now, indeed, would the government let me know the redress and remedies a consumer can obtain if he is injured by a faulty product as a consumer, but nonetheless, he is not a party to a consumer contract? Now, I believe that any claim could be conducted under a tortious claim head or a statutory claim under any product liability legislation. But I should be very grateful if the government can confirm that point. Third, it is important to note that insurance contract is not excluded from the bill. So it would be possible for parties to an insurance contract to exclude the operation of the bill in the contract through proper construction of the policy wording if the parties so intended. In the context of insurance contracts, I'm therefore concerned that a subject of insurance who may not be a party to an insurance contract, maybe he's not paying the premium, may not be able to enforce such a contract. In terms of the complexity and technical nature of the bill, and the fact that normal citizens and consumers in general will be affected by the bill, I would urge the government, and indeed the Law Society, to put in adequate resources and time to educate the public about the implications of the bill before its full enactment. And I would like the government to give an undertaking in this council to do so. Last, on behalf of my constituents, I would like the government to clarify unequivocally the implications of the bill on corporate documents. The first type of document I'm concerned about is the constitutive documents of a Hong Kong incorporated company, i.e. the Memorandum of Association under the new Companies Ordinance. Now, what is the effect of the bill on such constitutive documents, which traditionally only bind the shareholders and the company? And secondly, what is the effect of the bill on any public offer documents for shares or securities offered to the public under the Companies Ordinance or the Securities and Futures Ordinance? Now, the proper construction of the second question, I believe, of any public who subscribes for shares or securities under a public offer document should be a party to a contract, and the terms of the public offer document would become the terms of the subscription, and therefore those subscribers are not third parties to such a subscription contract. And any purported exclusion clause drafted under the bill will have no effect on the subscribers. Please, will the government confirm that my understanding is correct here? Mr. President, subject to my above comments, I support and would urge my honorary members of the Council from across the political parties to support the resumption of the second reading and the passage of the bill. Thank you, Mr. President.